Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. All of our fees are based on a sliding scale based on your income. That means the less you make, the less you have to pay. Today, I wanted to talk about disposing of cases in criminal matters in Massachusetts. So, most cases don't go to trial, and most criminal cases don't go to trial in Massachusetts. They are pled out by way of plea agreement or plea bargain, you might hear it called. By disposing of cases in this way, you're not taking the risk of taking your case to trial, and you have some more control over the outcome of your case. So what happens is in a plea bargain, in a disposition, it can be an agreed upon disposition or an unagreed upon disposition. And an agreed upon disposition is just like it sounds. Both you and the district attorney's office are asking the judge to do the same thing in your case. So you're agreeing upon the terms of your plea. In an unagreed upon disposition, as you might well imagine, the Commonwealth is asking for one thing, and we're asking for something else. You're they're asking for something that is more punishing. We're asking for something that's a little bit more lenient. And then you go before the judge, and it's always up to the judge to make a decision. So even in an agreed upon disposition, that's not so easy to say. The judge still has to approve the disposition. So even if we come to terms with the prosecutor, it's still up to the judge to say yes or no whether they're going to accept that plea. Same thing with an unagreed upon disposition. So the Commonwealth is asking for one thing, we're asking for something else. We both get an opportunity to make our argument to the judge as to why the judge should adopt our position, and the Commonwealth argues why the judge should adopt their position. The thing is, in an unagreed upon disposition, if the judge gives us anything more than what we're asking for, so if the judge is looking to punish you any more than what we've already agreed to, so let's say they instead of a 1 year probation, the judge wants to give you 18 months probation, or if there are no conditions of probation, the judge says, I want to have conditions such as to remain alcohol free with random tests or whatever it might be. If the judge exceeds our recommendation at all, we have the absolute right to withdraw the plea and to put the case down for trial. So that's something that's it's a great thing to have in our corner because we can try to resolve your case on acceptable terms to us. And if it doesn't work out, we're not obligated to take those terms. We do have an option of withdrawing the plea and putting the case down for trial. Now, whether or not you want to try the case is a whole separate thing. That's all dependent on the facts of the case. But in a unagreed upon disposition, the judge makes a decision. So the judge can adopt what we want. That's called a defendant capped plea, can adopt the Commonwealth's recommendation, or can come up with it whatever he or she wants to within the bounds of the law. What I want to point out to you specifically is what happens on an amended plea, or an amended charge. So say your case is coming up. As an example, say you're charged with theft of a motor vehicle. That's a felony, very serious charge. Um, Sometimes we can get the Commonwealth to agree to amend that charge to something less than that. In this case, it would be something along the lines of use without authority, use of a motor vehicle without authority, which is a lesser charge. So that's a lot better for us. So let's just say, following this example through, um, if you were to accept a plea on a theft of a motor vehicle charge, even if it's a continuation without a finding, what they call a quaff. We've discussed quaffs before, but just very briefly, a continuation without a finding has two big advantages. The first is that it's not a conviction. So if anybody ever asks you, have you been convicted of this crime, you can truthfully tell them that you have not been convicted. And you're on probation for a period of time. If everything goes well on probation, you satisfy any conditions of your probation, and you don't get rearrested, the charge will get dismissed at the end of that 1 year. So that's not a bad deal. A quaff is a pretty good deal for most cases. Usually you can get one quaff on your record. If you have several of them or more than one in the past, it's probably unlikely that a judge would go along with a quaff again. Although there's always that possibility. So that's not a bad deal. But here's what happens. Say you're on a quaff for that and you get rearrested for something else, or you don't satisfy your condition of probation or whatever that might be. You would be presented as a probation violator before the court. Now, if you're found in violation, the court can and commonly does convert your quaff to a guilty. So now you have a guilty on your record. And because the quaff was on a felony, you are now a convicted felon, and that will follow you for the rest of your life. You are a convicted felon. So what we try to do is we don't want you to be exposed to that. So we want to try to knock it down to something, to a misdemeanor. So at least, even God forbid, if you don't do well on probation, then if the quaff is converted to a guilty, then you're guilty of a misdemeanor. Still a serious matter, but not as serious, not as consequential as being a convicted felon. So what happens is, if the Commonwealth is willing to drop down the charges, amend the charges to something less, now we don't really have the opportunity to go in on an unagreed upon disposition, because what happens is, according to the rules, rules of criminal procedure, because the Commonwealth has already made that amendment, they've already given you a break, really, from dropping it from a felony to a misdemeanor. The judge has to accept their recommendation, or, I mean, the judge can refuse it, but the judge can't give us anything that we're asking for. So we can't ask for less than that. So to follow our example through, once again, if the charge is dropped to, if the charge is amended to something less, the Commonwealth asks for, let's say, a quaff for 2 years with drug and alcohol testing. We can't come back and say, we'll take the quaff, but we'll take it for 1 year with no conditions of probation. We don't have that opportunity, because we've already benefited by the Commonwealth making that change to us. And just as a little side note, in our example, a theft of a motor vehicle, you can't get a quaff on a theft of a motor vehicle. It would have to be dropped down to something less, because that's not quaffable, as they say. So when amending charges, it's a great thing, because you get the benefit of facing a lesser charge, but you get a little less wiggle room as far as trying to figure out how to plea out the case. So keep that in mind if you have a criminal case that's coming up for disposition. If you're facing that situation, I just wanted you to understand what's going on, what the mechanics are, as far as pleading out to that particular case. And it's not only that charge. That was just an example. There are a lot of charges that are serious that can get reduced, but that's at the discretion of the district attorney's office. So at Afford Law, please feel free to visit us, affordlaw.org. We have a lot of information there for you. All of our fees are based on your income, so that means the less you make, the less you'll have to pay. Feel free to book a free virtual appointment with me. I'd be happy to answer any specific questions you have about any criminal or family law questions in Massachusetts, because at Afford Law, we're making justice affordable.